Thank you very much. Madam Lederman, as I stated in my opening statement to you, it is now the year 2016. And I have to say that it is absolutely astonishing to me as a special needs parent that we're still having to fight this fight. Before you deliberate about this case, I'm going to ask you simply to step back and so as to not get lost in the proverbial trees and lose sight of the forest. And I submit to you that this case is actually an easy case to decide. Quite simply, Madam Lederman, anyone who thinks that tearing a child from his educational womb of where he has spent his entire life, and productively for that matter, under the belief that this removal is somehow good for the child, is absolutely insane. To this day, Westhampton Beach School District has never in its entire history provided for the post-elementary education of an alternately assessed child. And this history of bigotry and this history of discrimination, it needs to end now. This case can best be analyzed as both pre-enrollment issues and post-enrollment issues. With respect to the pre-enrollment complaints, the state review officer succinctly set forth the proper modes of inquiry for your deliberation. First, whether the Westhampton Beach School District had the right to refuse Aiden's enrollment for all academic years. Second, whether the Westhampton Beach School District was compelled to convene a CSE on my son's behalf for all academic years. And third, whether the school district ever harbored any valid and sufficient reason worthy of justifying Aiden's enrollment exclusion. And Madam Lederman, I submit to you that those were the specific points of inquiry set forth by the SRO, and I submit to you that those 3 points of inquiry have been emphatically answered. Madam Lederman, I use the word emphatically because it is hard to even imagine a more comprehensive, a more volitional, a more negligent manner in which Westhampton Beach violated Aiden's due process enrollment rights. First, Westhampton Beach violated the educational law contract that mandated enrollment. Second, it violated the specific Part 200 regulation mandate that compels enrollment and convention of a CSE. Third, it violated the historic course of dealing between the districts. And fourth, it violated all applicable tenets embodied within the protections of IDEA and ADA. Indeed, how more thorough could Westhampton Beach's deprivation have been? And the only distinguishing factor allegedly justifying this exclusion was that my son had Down syndrome. Madam Lederman, this is blatant discrimination, and Westhampton Beach affirmatively engaged in such discrimination, despite the painstaking, proactive outreach of my family. Shame on Westhampton Beach, and this district now owes Aiden due compensation for the years of his life that he will never get back. Madam Lederman, progressing to this year's CSE and this year's IEP, one only needs to analyze the very infrastructure of the same in order to conclude that Westhampton's recommendation was disingenuous, was predetermined, and was ill-conceived. Let's just look at the facts, beginning with the fact that Westhampton Beach did not even agree to convene the CSE until cross-examination held them to task. First, not even a single member of the Remsenburg CSE attended that meeting. Second, not even a single member of ESM CSE attended. And this is in express contravention of Part 200 regulation, which apparently Westhampton Beach feels it's not beholden to. Third, the Westhampton Beach CSE did not request a single outreach to my family to discuss possible methods for implementation of Aiden's IEP. Fourth, the Westhampton Beach CSE did not request any class profile of which the placement that it was recommending. Fifth, the Westhampton Beach CSE members were deprived of their ability to even think about whether Westhampton Beach could implement Aiden's IEP, but were rather preempted by Mary Ann Ambrosini's steadfast statement that Westhampton Beach did not have a program. Madam Lederman, what more do you actually need in order to determine that this recommendation was predetermined? What more do you need? Seriously, absent an outright admission, what more do you need? Westhampton Beach's CSE was an outright sham. And because of that alone, you should find that Aiden's due process rights were deprived. And that Westhampton Beach's subsequent recommendation shouldn't even be lent an ounce of credence. Fortunately, Madam Lederman, if you genuinely want to know what is best for Aiden, or even appropriate for Aiden, you don't need to guess. This is so because you have already been told by those who know Aiden best, and those who know Down syndrome teaching best. Here's the thing. Despite Mr. Seaman's attempts to mischaracterize the CSE committee's thoughts, the testimony revealed that they have always recommended Westhampton Beach as the primary choice. Don't let Mr. Seaman confuse you. You have heard the testimony. 2015, 2016 recommended Westhampton Beach as the first choice, and that was also the choice of the CSE members, Remsenburg CSE, for the 2016-2017 year. Don't let Mr. Seaman confuse you. In fact, the only reasons the word ESM ever appeared on any of Aiden's IEP documents was because Westhampton Beach refused to allow itself to be considered as an option. That is the only reason ESM appears at all in any document. You heard from our advocate, and you heard from us, and you heard from the only CSE that has ever been familiar with Aiden, and they all recommended Westhampton Beach as the primary choice. Madam Lederman, you don't need to guess. You only need to concur with the people who know Aiden best. Now, Westhampton Beach School District's argument rests upon the faulty assumption that its capacity to contract with other districts somehow equates to an unfettered discretion to outsource and segregate. And I respectfully submit to you that this is simply an erroneous conclusion. Indeed, the provision of FAPE is only satisfied when implemented in accord with the tenets of a least restrictive environment. And least restrictive mandates that his education be administered as close to home as possible. And it also mandates that his normal educational path shall only be altered when his educational needs cannot be met through the provision of special education and the allocation of related services. Madam Lederman, Westhampton Beach is Aiden's home community, and his educational needs have always been met through the provision of special education and related services. As such, what exactly is the issue here? Governing jurisprudence recognizes a home district preference for good reason. That is why it is actually incorporated into regulation and statute. And you heard testimony echoing this wisdom. As such, if a child is to be removed from the district, Westhampton Beach is compelled to show that such segregated placement is not only superior, but that such elements that allegedly make it superior cannot reasonably be implemented within the home district. And by the way, this is the burden of the district, and they have done neither. In fact, what has been conversely displayed is why the home district is so superior to an out-of-district placement, and furthermore, how Aiden's IEP can easily be implemented within district. In fact, it is already being accomplished by way of related service provision right now. Madam Lederman, this talk of program is misplaced, and it is actually only a fabrication of the district. Nowhere, anywhere in law or regulation is the word program mentioned. The law only calls for Aiden's IEP to be satisfied through the provision of special education and related services within the least restrictive environment possible. End of story. Now, Madam Lederman, before you cast your opinion on these matters, I would respectfully ask that you gaze onto the horizon and assess the ramifications of your decision. If you lend even an ounce of credence to the district's position, what you are essentially establishing is that any district can simply state that they don't have the capacity to fulfill any particular student's IEP, and therefore outsource and segregate that student. Think about the repercussions of that decision.
My decision has
Think-
no precedential value, Mr. Colon.
Think about what would happen if all districts embodied Westhampton Beach's philosophy. Where would Aiden go? Where would any student who challenged this unbridled discretion go? Indeed, the bad faith Westhampton Beach has exhibited is startling and is also disgusting. Think about what you would be letting them get away with. This is an untenable position, and that type of backward thinking would catapult us back into an era and zeitgeist long since discarded. Madam Leaderman, it is the year 2016, and incredibly, Westhampton Beach School District's historic legacy of discrimination continues until this day. I implore you to find that this district had no right to ban my son from enrollment, and that its subsequent disingenuous and ill-conceived outsourced placement recommendation is a sham. I ask you to do what is right, and I ask you to compel the Westhampton Beach School District to truly provide a free and appropriate education for my son consistent with law. I ask you to confirm what is obvious, and that is that Aiden's due process rights have been comprehensively violated. And I ask you to afford Aiden all of the remedies appropriate at law, inclusive of fees and costs. Thank you.